Call the meeting of the Carson City Planning Commission of June 28th to order. Would the secretary call the roll, please?
Chairperson Eswine.
Here.
Vice Chair Sattler.
Present.
Commissioner Borders. Commissioner Stoll.
Here.
Commissioner Monroy.
Here.
Commissioner Salerno.
Here.
A quorum's present.
Thank you. Ms. Monroy, would you lead us in the Pledge of Allegiance? Please rise for the Pledge of Allegiance.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. This thing's not working, so we'll take it off.
Okay, moving on. At this time, the public is invited to comment on and discuss any topic that is relevant to or within the authority of the Planning Commission, including any matter that is not specifically included on the agenda as an action item. So this is an opportunity, if you have something that isn't on the agenda that you want to talk to us about, for you to come forward and make your comments known. Seeing none, we'll move on to item 3, or item C for possible action, approval of minutes from the May 24, 2017 and May 31, 2017 Planning Commission meetings. Has everyone had an opportunity to review the minutes?
I'll move for approval. I'll move for approval.
We have a motion by Mr. Salerno for approval. And this is approval of both May 24th and the 31st.
Of both, yes.
Okay. We have a motion and a second to approve the minutes of the May 24th and May 31st, 2017 Planning Commission meetings.
Mr. Chair, given the attendance, did you want to take that separately? Because I know Commissioner Monroy was not at one,
okay.
but not the other. It just might be easier for the benefit of the.
Oh, okay. She wasn't at either, so we.
So I can abstain from both.
Sorry, my mistake.
Okay, we have a motion and a second. All those in favor of the motion signify by saying aye.
Aye.
Opposed? Abstain? Ms. Monroy, abstention, and Ms. Stoll abstains. Okay, we have one vacancy, just so that everybody knows. There's generally a 7-member planning commission, but we have a vacancy. So if anybody's interested, they can submit their names to the city manager's office, I believe. Moving on. Item D, modification of the agenda. Items on the agenda may be taken out of order. The public body may combine 2 or more agenda items for consideration, and the public body may remove an item from the agenda or delay discussion relating to an item on the agenda at any time. Are there any changes to the agenda?
Mr. Chair, can we speak to C1 when you have a chance?
Oh, C1. I'm sorry. Let's do the modification, and we'll get back to that.
C1 is for information only. It's not an action item. In reviewing the minutes of your April 26th meeting, which you did approve, you'll recall you reviewed the Montessori school at that meeting. There was an error in the minutes regarding which findings you could not make. We did listen to the tape. We do know which findings you could not make. We're clear on that. Just there was a scribbler's error, and so we have provided you in this memo with the correct motion or verbiage, if you will.
Okay, and there's no action required on that?
No, sir.
Okay, moving on to item D, modification of the agenda. Any changes to the agenda? Mr. Plemo? Ms. Sullivan? Any members of the commission want to change anything around? Okay. Moving on, disclosures. Any member of the commission may wish to explain any contact with an applicant or the public regarding an item on the agenda or the business of the commission. Are there any disclosures? Hearing none, we will move on to and open the public hearing. Item F1, SUP-17-064 for possible action to consider a request for a special use permit from Carson City School District, property owner Carson City School District agent J.P. Kopolos, to allow expansion of 3,000 61 square feet of an existing 54,315 square feet to a total of 57,376 square feet, and modification of a school on the Fritch Elementary School on property zone public located at 504 Bass Street, APN 001-111-01. That was easy. Ms. Sullivan.
Thank you, Mr. Chair. As the chair explained, the request is to have a 3,061 square foot addition to a 54,000 square foot building. So it's a relatively small addition to the building. On the site plan you received, you see that the additions are essentially 3 small locations, and there's another graphic that was in your packet that kind of is color-coded and shows those additions slightly better. The additions are relatively minor compared to the entire building. There are no additional students or teachers anticipated as associated with these additions. Instead, they're trying to modify the access points to the school. The commission will remember that when you consider a special use permit, you need to make 7 findings of fact in the affirmative. The staff has reviewed those findings of fact in the staff report, and we were able to make those in the affirmative with conditions. I'm happy to go further in depth on this. Mark Johnson from the school district and John Kopolos, the architect, are present as well. And if you have any questions for me, I'm happy to go into it, but I think it's a pretty straightforward application. It's because of the public zoning that's subject to the SUP. Thank you.
Thank you. Are there any questions for staff? Okay. Does the applicant want to make a comment or anything? I would agree with staff that it's a pretty straightforward application. Is there anyone from the public who wishes to address this item? Okay, seeing none, I'll bring it back to the commission for consideration. Yeah.
I move to approve SUP-17-067, a request from Carson City School District, property owner Carson City School District, agent J.P. Kopolos, for a special use permit to allow modification of the Fritz School by 3,061 square feet from 54,315 square feet to 57,376 square feet to create connections for all the buildings for a single point of entry by enclosing an existing canopy, adding a corridor, office space, and classroom on property zone public located at 504 Bass Street, APN 001-111-01, based on the findings and subject to the conditions of approval in the staff report.
We have a motion. Do we have a second? Mr. Salerno?
I would like to second it.
Okay, we have a motion and a second by Mr. Salerno. Any further discussion? Okay, all those in favor of the motion signify by saying aye.
Aye.
Opposed, none. Unanimous in favor of a motion passes. Okay, moving on. Item F2, SUP-17-066 for possible action. To consider a request for a special use permit from Grant and Joan Family Trust, property owner Grant and Joan Family Trust, to allow a 6-foot tall fence in the front yard setback on property zone single family 6,000 SF6 located at 610 Westview Avenue, APN 003-056-13. Ms. Sullivan.
Thank you, Mr. Chair. Hope Sullivan. This one's not as easy as the last one. It's a little harder, so I'm going to talk a little longer. Fences. You don't see fences too often, so let's go over what our rules are regarding fences to make sure we're all on the same page. This property is zoned SF 6000. That means it has a 20-foot front setback. So you take your front property line, you go back 20 feet, and that's where you can start building. But we don't have a building, we have a fence. What the fence regulations say is that if you have an open style fence, i.e. a fence you can see through, that's up to 4 feet tall, or more than 4 feet tall, I'm sorry, or if it's a solid fence, 3 feet tall, more than 3 feet tall, it cannot be located in that 20-foot setback. So let me try that one again. If you have a fence that's open and more than 4 feet tall or closed and more than 3 feet tall, you may not have it within that 20-foot setback area. What you have before you is a fence that's open and 6 feet tall. Therefore, per the fence regulations, it should not be in that 20-foot setback area. But you have the luxury, per section 1.13.7 of the development standards, it says fences within the setbacks may be permitted in excess of the ordinance requirements by approval of special use permit. The Planning Commission can issue a special use permit. So the applicant was intending to build a 6-foot fence for the purpose of keeping deer out of the property, and I have some photographs of his fence. This fence also does go right up to the curb line. And I want to talk a minute about Title 11. You guys don't work in Title 11. Title 11 addresses encroachment permits, so that's when you do stuff on the right-of-way. Our Public Works Director is responsible for determining what improvements may go on the right-of-way, not the Planning Commission. So in your report, you read some information about different encroachment standards for Chapter 11. But I will just remind the commission, just like when we had the casino and we had to talk about Title IV and we said the Planning Commission doesn't enforce Title IV, you do not enforce Title 11. So there is, we don't know, short of a survey, exactly where the right-of-way ends and where private property begins. So what I'm going to advise the commission to do is to look at the 7 findings of fact, consider this request for a 6-foot tall fence. In this case, the applicant, Mr. Gardner, has already constructed the fence. So he's seeking permission after the fact. He's allowed that due process. And if you feel like you have locational standards that need to be put into place to make the 7 findings of fact, then we can incorporate those into the conditions. But I don't want you to get too bogged down on Title 11 because that's not your purview. No matter what you do, if something's on the right-of-way, the Public Works Director gets to review it and gets to decide. You don't get to trump him, and that's just the rule. So hopefully that makes sense. I went back out there today, and I thought, oh, wow, there's all these other fences out there. I should inventory them and see what we've got. So on the block, and I only stayed on the block, we have 5 other fences. In this slide, I've given you the height of those fences and the distance from the curb, because I think distance from the curb is something that I'm seeing coming up in the correspondence. So I wanted to provide that information to you. So you'll see most of the fences are under 6 feet. We do have, if you went out there, there's a solid wood fence that's 6 feet tall. That one's 4 feet 4 inches from the curb. The other ones are, weirdly, 4.2. 3 of them, right? And then we have a one that's just shy of 3 feet tall, that's 6.5 feet from the curb. So I just wanted to give you that as reference, so if you were able to go to the site and visit the block, you'd have some idea of the distance of those fences. Again, because this is a request for a special use permit, you have the authority to allow the fence to be taller than the 3 feet, or 4 feet, I'm sorry, that would be allowed within that 20-foot setback, if you can make the 7 findings of fact in the affirmative. The staff did make those findings of fact in the affirmative with conditions, and we are recommending approval. Mr. Gardner is present, and I'm happy to answer any questions.
Okay, any questions for staff? Mr. Sattler?
Looking at that fence, is it because the posts are 6 feet? Because that fence, solid fence line is not a 6-foot fence.
Yeah, what
I
it
was up
is it's okay, what you see in terms of the wrought iron portion, that's a 3-foot section of fence. The posts go up, and what you can't see very well in this photograph is there's wires. And the wires are in this one,
I didn't notice the wire.
yeah, so here I see 3 strands of wire in this photograph. And the wires are intended to keep deer from jumping the fence and eating the vegetation.
I was just up there yesterday, and I didn't even notice the wire. I just saw the fence, and I'm going, that doesn't look like a 6-foot fence to me.
Right, so the wire elements are what's creating this, and the
Oh, I see.
the post.
I didn't even notice. Wow. Thank you.
Okay, are there any other questions for staff?
So if the wire wasn't there, it would be a legal fence?
No, well, I'm not sure. It would be a 3-foot open style fence, so it would be allowed to encroach into the setback. The question is it on private property or does it require an encroachment permit? And that's not within the Planning Commission's purview. That's something the Public Works Department will work out with Mr. Gardner.
Because I had also noticed up in that area that there's not solid sidewalks. There's spotty sidewalks here and there, and I'm guessing maybe the 4.2 is, I figure a sidewalk would be 4 feet wide for setback or something. So.
No, you're right, and I think we speak to that in the staff report. I went out there first time about a month ago to see, and there's not a contiguous sidewalk. It's a couple properties have portions of sidewalks in front of them. There's some properties that have significant landscaping right along the curb that would preclude a pedestrian from walking through there. So it's really kind of a bit of a hodgepodge.
Just a couple houses down, I believe there was some railroad ties and plantings and that came all the way down and that sort of thing, so.
Any other questions? Okay. Mr. Gardner, would you like to address this? Please state your name, and
Yes, Grant Gardner.
do you have any additional information you'd like to add to this?
I have a lot. There's a lot of misunderstanding.
Could you speak into the microphone a little bit more, please?
A lot of misunderstanding with some of the contacts I had with the Planning Commission, and the most glaring one, and kind of, if you look at my variance application, the only thing that's mentioned in the application is the height of the fence. Nothing about the location of the fence. And the reason for that was that after I received the complaint, notification that somebody had complained about the fence, I called the enforcement officer and talked to her briefly and indicated that the people that had put the fence in, Tahoe Fence, who've been in business 40 years, thought that I could locate the fence at the curb line based on the zoning on my particular property. And she said, well, that's not what our Steve Pote came up with, but you'll notice his name is also on the form that you received. Give him a call. And so I called him. This is the morning after I received it. And he answered his phone. He said, I'll check it again. I'll call you right back. He called me back within 5 minutes and said, oh, I made a mistake. That fence, your property has the ability to go clear to the curb. So from that moment on, that was off my table, where it was located. The people that made the complaint, that was their reason for the complaint. And so that was not an appropriate reason for a complaint to be issued based on what Mr. Pote told me on, let's see, I have a date here, the 4/24, March 24th, when I called him. And so I focused on the height of the fence, and as you've noticed, if you went out and looked at it, it's, even though it's 6 feet tall, it's only the posts that are 6 feet. And like if we stand in our house and look out the window, we can't even see the wires. So there's absolutely no infringement, and the fence works. It works. We have not had one deer. Our roses are blooming the first time in 6 years. All the vegetation in that front yard is great, and the vegetation went all the way down the driveway on the south side there. Roses, herbs, other things, and that was just pretty much mowed down the last 5 or 6 years. And I tried everything. I slept outside with a mask. That didn't bother him. I did chants. I planted soap. I did everything. I went to the feed stores, and they all had, ways of keeping the deer. None of them work. Trust me. If the deer are hungry, they're going to eat whatever's there. And I thought I had found a great solution, and I think it's a beautiful fence. It's a beautiful fence. And there were 2 other positive things that happened with this fence. I hadn't realized it until we finished it and we started using it. And I have a dog that's a Griffon Wirehair, very active dog, and my dog can now run my entire property and is safe and cannot get out. And we have a 2.5-year-old grandchild who thinks she's at Golden Gate Park here, and it's safe, and the deer cannot get in there. So I have a whole litany of the timeline here, and I don't really want to bother you with that. If you had any questions, maybe I could address those.
Does anybody have a question for Mr. Gardner? I have a memo here in front of me from Stephen Pote that states that the engineering division provided a condition of approval to the planning division regarding or referencing section 11.12.030 of the Carson City Development Standards, which requires a fence in the right-of-way to be no more than 4 feet tall. However, section 11.12.110 gives the Public Works Director the authority to allow a deviation from this standard. And he then goes on to say that if the fence is moved back from 6 feet from the curb, there would be no sight distance issues, and so that a 6-foot fence would be allowed and wouldn't be contrary to the intent of the standard. So he's saying in this memo that
Right.
it needs to be moved.
I know that. Which was a complete surprise to me. I got that memo Tuesday. Or no, I got it a little earlier than that. Maybe I picked it up when I paid for the variance, probably Thursday or Friday.
Yeah. But again,
And again, as I read that, I kind of discounted that based on my experience with him, where he had
Yeah.
said, you can be at the curb with a fence.
well, I'm going to have to, I understand your dilemma, but the Planning Commission is not, we cannot make a decision
Right, yeah,
on the
I
location of the
understand that,
fence.
I understand that,
We
yeah.
we can talk about the height of the fence.
Yeah.
And I live in that neighborhood too, and I know that the deer are a problem.
Yes.
And I sympathize with you 100%. And I don't think that the way you've got it set up is too objectionable. I mean, I don't care for fences in front yards, but that's a good compromise, I think.
Yes. I don't either. I've never had a
Yeah.
fence. I've been there.
No, I understand.
I've been there for 40 years.
Yeah.
Yeah. And you see these fences all on the West Coast, the coast of Oregon, and that's where I first saw them. And I go, what are those wires? Are they
Yeah.
are they charged? You know, is it an electric
Right.
fence? They go, no, the deer just won't jump.
Yeah.
And they can see them in the dark, and so that was I made a plan.
Yeah.
And,
Okay. Well, I don't have any more questions. I think we understand the dilemma.
yeah.
And unless you have anything further, I'm going to add, I know that there are some people from the public who wish to address this also.
Yes, let me see. So, no, I think I've said enough. Thank you.
Okay, thank you. Okay, anyone from the public who wishes to address this item? And I should also state that we have several letters, and when the public is done commenting, I'll summarize those letters and we will incorporate them into the record. So please state your name for the record and.
I think I did. Let me put my phone number. Hello, my name is Carol Payne, and I live at 605 Westview, which is directly across the street from the applicant's house. And I did also submit a written letter, but I felt like I also wanted to come today and say a couple of other things that I didn't put into the letter. And this has been really difficult for me to submit the letter and to come here, because I have considered the applicant our friends and neighbors for 31 years. As I understand it now, the staff's recommendation is that the fence should be relocated to 6 feet from the curb, but that you may still issue a variance so that the height can be 6 feet tall. I agree that the fence should not be at the curb, but I also think the fence should not be 6 feet tall. I know you can't see the whole thing area, but you see those 6-foot posts coming up. My husband and I did try to communicate with the applicant as the posts were being put in, first via text, and then we called and left a message, but our phone call wasn't returned to us. Now, the Carson City Planning Division, I think you have a really great page about the fences, and I think it's pretty easy to locate, and it says what's allowable and what is not allowable. And I think that compliance with the rules gives our neighborhoods consistency. I know you said that there's kind of a hodgepodge, but for the most part, some houses have fences, some don't have fences. The ones that have the 6-foot tall fences, those are pretty much on a corner, if it's the two I'm thinking about. And you have special guidelines in here for the corners. But whether they have a fence at the house or they don't have one in front of the house, we don't have any homes with a 6-foot fence at the curb. The deer population. The chairman mentioned that he lives in the area. He knows most of us here in Carson City share our town with the deer. And if, as a planning commission, you warrant or grant a variance for a 6-foot fence on the front side of the house, there's going to be a lot of applications for fence variances. And then our town will be hidden behind 6-foot fences. So in my written address, I commented about the safety, the parking, and what we see as the home value impact. Again, I support the staff's recommendation that the fence be away from the curb, but I do oppose a 6-foot fence on the front property. Thank you.
Thank you. Is there anyone else who wishes to address this item?
Hi, my name is Piran Takis. I'm living at 607 Hillcrest Road. It's my grandmother's house. She submitted a letter, Joanne Payne, but I wanted to come in today and express some of our shared concerns. So my biggest concern is just the precedent or the standard that this would set if this was approved. My understanding in making your decision to approve a variance is you consider a number of factors. You consider whether there's specialized circumstances that would warrant someone acting outside of the municipal code. And you also consider whether that change would lower or affect neighboring property values. So regarding the specialized circumstances, I read the application and my impression that was that the biggest motive for this fence was to keep deer out of the yard. We all live in Carson City. We know the deer are everywhere. It's in my opinion, we all want them out of the yards. But at the same time, other people in the neighborhood and other people in Carson City are coping with the deer problem while also staying within the municipal code. In my opinion, that's not a specialized circumstance that would grant a variance. And then regarding property values, a number of people in our neighborhood as well as outside of our neighborhood have commented on the fence, that they don't like the appearance, that they don't like that it's not within the municipal code. Now, it's hard to judge whether a change will affect property values, but to me that indicates that if people don't like the aesthetic, they would be hesitant to move into the neighborhood, which would then impact our property values. So those are my two biggest concerns with regard to this application. I think that if this was granted, there would be a surge in variances for 6-foot fences. And whether intentional or not, that could really alter the shape of Carson City's municipal code. So those are my biggest concerns, and thank you for taking them into consideration. Yes.
Thank you for your comments. Is there anyone else who wishes to address this item? Okay. We'll close the public comment portion and bring it back for the commission for consideration. Go ahead.
I kind of mentioned earlier, if the screening wasn't there, would it, because of the post, would it still be considered a 6-foot fence?
If the post and the wires were not there, it would be a 3-foot fence. Then this would not be before this commission. The Public Works Department would still be taking it up because based on the best information we have available, we believe it's on the right-of-way.
So the fact that the posts are there makes it a 6-foot fence regardless of what's between the posts on the top?
I think it's the post coupled with the wire. The wire helps delineate the area.
Mr. Salerno.
I've been out and looked at it a couple times, and I've looked at the surrounding area, and I know it's a problem, and it's been there for a long time, generally in the area. But I think that it's really important that we have at least, at a minimum, a 3-foot distance of the fence from the curb. But of course, that doesn't make any sense because there's a tree right there. And so therefore, I think that's why staff has recommended 6 feet. There may be other reasons as well. I don't have a problem with the wire, other than I think there should be a condition that the owner may not put climbing vines, over the wires, because I can see that it would become totally obscure up to 6 feet high should they do so. So I would be willing to move forward with the staff's recommendation. And it could possibly be that I didn't have a tape measure with me to measure exactly where that tree is, but I think that 6 feet would be just to the west side of the tree. And as long as the posts weren't put right near the tree, but off to the sides, I don't see any reason why you couldn't put a fence at that location. Those are my feelings about it. I think that it's important, it's precedent setting, number one. If we allow the fence right at the curb, what's to keep somebody else from wanting to do exactly the same thing? And I think that it would be, almost, if that would, the way it is now, if somebody tried to park parallel in front of the house, they couldn't get out of the car on the west side of the car. So that is a problem, and I think that staff has come up with a good way of resolving the problem, and I'd recommend we go with that, with just a further condition that vines would not be allowed to grow on the fence and on the wires up above.
Ms. Stovall.
Thank you, Chair. I will not be supporting the motion to approve the special use permit. I think it's a mistake. I do not think that this proposed special use permit meets the 7 findings. I could barely come up with maybe 2 findings that I believe the special use permit would meet. I think it would be a terrible precedent. There's a reason why the fences are supposed to be no more than 4 feet high in the municipal code. And this would be, as Mr. Salerno said, would be a terrible precedent. I've been bicycling around neighborhoods for the last 2 weeks, and I've never seen any 6-foot-high fences in the front yards in Carson City. I think this would be a terrible mistake to approve the special use permit, and I do not believe it meets the findings. Thank you.
Well, I am somewhat conflicted on this because I think that there are instances in this particular neighborhood where there are fences that are greater than the 3 feet, even though they are set back from the road or from the curb, and in some cases they are sight obscuring fences. I don't know if they're actually 6 feet tall, but in this case, you know, he could plant trees there, and there would be no. We would have no say over that. A hedge is not a fence. I don't think it comes under the same definition, even if, and especially if the trees are separated by some space. To me, the issue is the location of the fence, which is not in our purview. The issue is the height of the wires in this case, and you know, I have to admit the wires are not very noticeable. And if it weren't for the posts, you probably wouldn't even know that they were there. As Mr. Sadler has pointed out.
Right in front of it, and I'm going, it looks like a 4-foot.
Yeah. But I agree that if we approve it, then we are establishing a precedent. But I don't know how you deal with, you know, a situation where where there are others who have already created the precedent, even though it's not, you know, it hasn't been brought to the attention of the city. The city has taken no action on those fences that are in violation of the code. Ms. Monroy.
Thank you, Chair. Elise Monroy for the record. So I don't want to say I'm on the fence, but no? Nothing? Oh, come on, guys, wake up. Okay, so I appreciate that we're talking about the 6-foot height, and I understand the precedent that we're setting with that, but I think what is making this a challenge maybe is the openness of the fence. So I don't know, I don't remember if there was, so could, and this actually kind of dovetails on what Commissioner Salerno was saying, could we establish a condition that it stay an open fence and there aren't creeping vines or anything like that that do obscure it? Because then it's less of, it doesn't close off the property. And then would the precedent then be 6-foot open fences, or is the problem that we're just saying 6-foot fences are okay? So that, I guess that's just rumbling it around in my head.
I agree. I mean, that is the conundrum.
Or if you painted the top part of the post the color of the house, you probably would hardly even notice them. You know, it would be, they'd blend right in with the house. I wouldn't have even seen the posts then, probably.
Somebody might repaint the house.
I'm going to ask Mr. Yu to address the issue of all the other nonconformities.
Well, so, Mr. Chairman, if I may, the first point I'd like to just establish for the record here, and this is sort of a commentary on one of your earlier statements just a couple of minutes ago, and this is made without urging approval or denial of this SUP. I just wanted to clarify for the record that with respect to the height of walls as well as hedges, those are all incorporated in the same division standards as a fence. So the same requirements for the height would also be applicable for hedges. That was a statement you made earlier, so I just wanted to be clear for the record just in case that factors into the Commissioner's consideration of the height of this fence.
However, if you planted trees with the separation between the crowns,
Right.
then you you might establish the same effect as a hedge, but it wouldn't be considered a hedge or a fence.
I agree. I think that's a valid point. I think this is where you kind of get into the weeds with definitional considerations. What actually constitutes a hedge? A hedge, based on my understanding and reading of those code provisions, is not actually defined. So you do kind of wade into a murky area there where, you know, if you have a bunch of trees lined up, stacked one against another, does that actually constitute a hedge then? And if it does not, in practicality, does it actually result in the same consequence? I mean, that's a question I can't answer on the record today, unfortunately, but I certainly see your point. But that's an observation and comment I wanted to make just for clarity on the record.
Okay, and I stand corrected on that statement. Well, I guess if there's... We have Mr. Salerno, who in favor of the fence, correct?
I think in accordance with staff's recommendations, yes.
Okay. Well, I
Want
would...
me to make a motion?
I would suggest that we entertain a motion at this point.
Mr. Chair, can I offer some wording that would capture Mr. Salerno's concerns as well as Commissioner Monroy's? Condition 2, which currently reads, "All development shall be substantially in accordance with the development plans approved with this application, except as otherwise modified by these conditions of approval." Perhaps an additional sentence, if that's where the commission wants to take it, that says, "Enhancements may not be made which would compromise the openness of the fence."
That would be satisfactory. I would make a motion with that included. So I move to approve SUP-17-067, a request to revise a special use permit from Anthony Giadalis.
You're reading the wrong
Well, pardon me. I'll start over. I had the wrong one on the pile. I move to approve SUP-17-066, a special use permit request to allow an increase in the permitted fence height in the front yard setback from 4 feet to 6 feet on property zone single-family 6,000 located at 610 Westview Avenue, APN 003-056-13, based on findings in the conditions of approval contained in the staff report and including staff's recommendation of item number 2 of their recommendation of approval.
For the record, the additional language on condition number 2 per the motion would be, "Enhancements may not be made which would compromise the openness of the fence."
Okay, we have a motion. Is there a second? We have a second.
Monroy, I'll second.
We have a motion and a second. Is there any further discussion on this item? And then I will call for the vote. All those in favor of the motion signify by saying aye.
Aye.
Opposed?
Opposed.
No. We have 2 noes and 3 approved. Motion passes. Candace and myself. Okay. The motion passes. You get a 6-foot fence, but you have to work it out with the Public Works Department as to where it's going to be located. Okay, moving on. Item F3, SUP-17-067, for possible action. To consider a request for a special use permit from Anthony Giorgatis, GTI NV, property owner, DBB Holdings, Inc., to allow expansion of an existing medical marijuana establishment dispensary on property zone general commercial located at 135 Clearview Drive, Unit 119, APN 001-161-20. Ms. Sullivan.
Thank you, Mr. Chair. Hope Sullivan, Planning Manager. The request is for a special use permit to expand the existing medical marijuana dispensary located in the southern part of the city. The municipal code allows for 2 dispensaries in Carson City. This is one of those 2. The applicant is seeking to expand into a neighboring tenant space. As part of preparing the staff report, the staff reached out to the sheriff's office because I wanted to understand if they were okay with the conditions of approval that were initially put in or if they had any suggestions for modifications. The assistant sheriff advised he had no suggestions for modifications, that the existing operations were, I'm not going to say they were working, he had no suggestions for modifications. So we did do that outreach. Again, the Planning Commission can approve the special use permit upon making the required 7 findings of fact in the affirmative. The staff was able to make these findings in the affirmative as outlined in the staff report, subject to conditions of approval. We have reviewed this application for compliance with all of the standards required for medical marijuana dispensaries, and does meet those standards, or to the extent it's an operational standard, the standard has been included in the conditions of approval. Rebecca Gaskin is present representing the applicant, and I was fairly brief on this one, but I'm happy to answer questions. I think it's a pretty straightforward expansion into the neighboring tenant space.
Thank you. Are there any questions for staff?
I have.
Ms. Monroy.
Thank you, Chair. I don't think it's technically about this application, but I think I just would like to understand process going forward. So as we move to a retail market, it's my understanding that the medical dispensaries will all have the first take at applying for retail applications. So what will happen then if and when this medical dispensary applies for a retail license? And then to dovetail on that, are we going to have separate standards for where medicinal facilities can be and where retail facilities will be? If so, have those been established yet? And if this were to move into a retail facility, will there be problems? Or maybe not problems, but will there be issues if there's going to be a separate standard for where they can go?
Lee Plumwell, Community Development Director. So a lot of questions. So most of that we don't know because we haven't established the standards. Just a little bit on the timing of that. On July 6th at the Board of Supervisors meeting, we'll be having an item to get direction regarding that. So we don't anticipate the Planning Commission even looking at recommendations for possibly looking at recommendations wouldn't be before the July meeting for dispensaries and the regulations related to that. What was the other part of the question? So the combination. So the approval. Oh, and I would say so. This allows them now only to expand, and it's only under the medical marijuana establishment. This grants no rights to use this facility for recreational marijuana unless ultimately the regulations would allow it to be here.
And Elise Monroy for the record. So then, because I remember about a year ago, we had a couple applications about dispensaries where there was like a name change on the application and it had to come back to us for approval. So if and when these dispensaries apply for a retail license, will we have to approve that?
That depends on how the regulations. I can't answer that now. How that would be handled. It depends on what the requirements are, if it's separate or if it's a dual license, or if the existing ones are allowed to be there. I think those are questions still to be answered.
Okay, thank you. That's helpful.
And that will also, just to follow up on that, after the Board of Supervisors gives you direction, you will be drafting revisions to Title 10, or 18 rather, to deal with the location and requirements for retail marijuana facilities. And so they will come back to us for review, just as the medical marijuana regulations were before us, before they were approved by and adopted as part of the code.
I wasn't here for that. I didn't know that was the
Yeah,
process. That's
yeah.
good to know. Okay, thank you.
Yep.
Well, along that same line, I was thinking the same thing. My difficulty a little bit is when we approved the medical establishment, they knew there were so many people in this area with medical marijuana cards or whatever that would use the facility, and we kind of did parking and all that based on that stuff. So until those regulations are done, if they're expanding, expecting more for the recreational, we're changing possibly the whole traffic flow and everything in that area, because we don't know how many recreational people will be coming, that's just a concern I have.
But we are only looking at the medical marijuana facility at this point.
Okay, I got you.
They are looking to expand the medical
Just their
marijuana
medical.
facility.
Okay, thank you.
I mean, we all know what the long-term
Okay.
potential is. I'm not saying that it's a fact, I'm just saying that the
Gotcha.
potential is
Okay.
there. But we're just looking at the medical marijuana facility. Okay. Would the applicant like to address this?
Thank you. Oh, is this on? Can you hear
Yes.
me? Okay, thanks. Rebecca Gasca for the record. Here on behalf of RISE and the applicant Anthony Georgiadis. It's a really tough name to say. But yeah, we appreciate the consideration. Really, the intent of it is because we've actually seen quite an uptick in medical registrants that we're serving in the area. As you know, Douglas County has prohibited the use for medical marijuana, so we see a number of patients from there, in particular South Lake. There are no other, there's one other local dispensary, of course, because there are 2 allowed by code. But we see people traveling in from kind of the rural areas for us to visit us. And so the intent of this is to expand the footprint. There are times when we have, frankly, too many patients to be able to serve efficiently. And the expanded footprint will allow people to consult with our team in a more spread out manner, so that when they're discussing what some of their needs are, they're not being overheard by, other patients in the area. So really, its intent is to allow more one-on-one communication, with a little bit more privacy for patients who are coming in. So you'll see that expanded footprint. Also, if any of you haven't been in yet, please let me know. I'd love to bring you in so that you can actually see how it functions. The retail kind of display area is very, very small, and there are a lot more participants now from a commercial standpoint, people who are cultivating medical marijuana and who are creating products that people are consuming, and we just don't have the shelf space to be able to demonstrate what those products are to help educate the patients on what their options are. Otherwise, we have to just default to like a price list, and especially for new patients, it's a lot easier for them to understand when they can actually see visually what the product is. And so the floor plan allows for some additional shelf space. Of course, nothing changes. We still have to pack everything up. Things have to be behind locked lock and key. I mean, none of that is going to change at all. So that's probably why there was no specific recommendations coming out of the sheriff's office. That's it.
Any questions for the applicant? Okay, thank you. Is there anyone from the public who wishes to address this item? We have one letter from J&J Summers LLC in opposition to this approval of the special use permit. Is there anyone else who wishes to express any? Okay. Then I'll bring it back to the commission for consideration or a motion.
I move to approve SUP-17-067, a request to revise a special use permit for Anthony Giraldelis
GTI Nevada property owner DBB Holding Incorporated to allow an existing medical marijuana dispensary to expand its tenant space on property zone general commercial located at 135 Clearview Drive, Unit 119, APN 009-161-20, based on the findings and subject to the conditions of approval contained in the staff report.
Okay, we have a motion.
Second.
We have a second by Ms. Stowell. Is there any further discussion? Mr. Salerno?
I cannot vote for this, for approval of this item, because it is a violation of federal law, as well as other reasons that I have. I swore an oath when I became a member of this commission that I would follow federal law, and that would be in violation of my oath. So I will not vote for approval for this item.
Okay. Is there any further discussion? Entertain a motion, or let's take the vote on the motion. All those in favor of the motion signify by saying aye. Aye. Opposed?
Aye.
We have 4 yes and 1 opposed. Motion passes. Moving on. Item F4 for possible action. SUP-17-068. To consider a request for a special use permit from Pia Wood, Little Timbers Academy, property owner Capital Christian Center, for a change of ownership of an existing child care facility as required by the current special use permit, SUP-05-114, on property zone limited industrial located at 1987 Old Hot Springs Road, APN 008-921-10. Ms. Sullivan.
Thank you, Mr. Chair. The subject property was built as a child care facility in 2003 and has functioned as that use since that time. The applicant is seeking to continue the use, but SUP 05114 does not allow for a transfer of ownership. So the applicant must seek their own special use permit. The staff would note that the subject zoning is limited industrial, and a child care facility is a conditional use in the limited industrial zoning district. I want to bring this up because in looking at it, and we recently had a school in an industrial area, so I want to speak to this specifically. When you visit this particular site, it feels more like an office park than an intensive industrial use. The property across the parking lot from the subject property is an office, and the property next door is a day spa. So it doesn't have the level of intensity that some of our other industrial areas have. My recommendation may be different if this was a heavy industrial area. Access is from Old Hot Springs as well as via College Parkway via recorded access easements. There have been some questions in the community about access to this parcel from College Parkway. We did pull maps to verify that there are lawful access easements, but even independent of that, the access from Old Hot Springs is perfectly fine to access this site. Again, the Planning Commission can issue a special use permit upon making the 7 required findings of fact. Staff can make those findings in the affirmative, subject to the conditions of approval, and we are recommending approval of this application. I am not including in the conditions of approval in my recommendation any restriction on transfer of ownership. So should there be future transfer of ownership, it would not be subject to further review by the Planning Commission. The applicant, Pia Wood, is present, and she does have a presentation. And I'm happy to answer questions.
Thank you for that. Is there any question for staff? Ms. Stowell.
Just on the state licensing, sometimes it's a chicken and egg thing as in terms of whether the facility is licensed first and then they receive the approval. Sometimes the state will say, no, we want to make sure you have the local approval first. So how does staff normally handle that?
There have been times when I've had, particularly in-home daycares, where the state has requested verification that's lawful. With the more commercial facilities, I haven't had to sign off on anything for the state.
So I can chip in a little bit on that matter as well. I don't have NRS in front of me right now, unfortunately. So I ask that you not rely on this, but based on my recollection, the last time I looked at NRS, the licensing scheme that the state has implemented with respect to these types of facilities is that local government may also implement ordinances if they chose to do so. My review of CCMC is that Carson City has not elected to do so, and therefore the licensing provisions that these facilities would be subject to are established under state law.
Any other questions for staff? Okay, would the applicant like to address this issue?
Thank you, Commission. Now, I'm not Pia Wood. I'm actually her husband, Travis. Pia's right here as well, though. We have a little PowerPoint I made. This is my first time at a Planning Commission meeting, so wasn't actually 100% sure what to do, but hopefully this works. Great. All right, so a few things I'm going to talk about today. You can go to the next slide. First, just a little bit about us, myself and Pia, and also our director, Kim. Talking about Little Timbers Academy as a business. Then I'm going to talk a little bit about child care in Northern Nevada and Carson City, the actual facility, and then the work done so far. So next slide. Thank you. So both Pia and I were born and raised here in Northern Nevada. Pia went to Carson High School here. I went to Dayton High School. 2 young children. I work at Microsoft, as well as helping Pia oversee the operation of the child care center. Kim Grundy is also in attendance today. She's our child care director at Little Timbers Academy, which is located on 151 Park Street here in Carson City. She actually previously owned and operated ABC Learning Center, which was in that same facility before we took over. We can go to the next slide now. So Little Timbers Academy, as I previously mentioned, we took over in January 2015. We offer care right now for 73 children. We teach basically from 5 weeks old all the way through preschool. We have a number of good features, communication systems, advanced security. We also accept children's cabinet. Over the last 2 years, we've actually been at max capacity with the full wait list, and we've been basically looking to expand for quite some time now. Next slide. A little bit about childcare in Northern Nevada. Some of the direct economic benefits, so, and this was pulled from Insight Center for Community Economic Development, but it generates $345 million annually, provides 9,000 full-time jobs, and of course, building a ready workforce for the future through education. Another thing, indirect economic benefit, more child care options enable parent options for how they choose to raise their children. It enables more parents to go to work without many options. Sometimes they have to leave their jobs and ultimately causing turnover in the workplace and economic loss. Nationally, more than 1/5 of all unscheduled absences from work are because of child care issues. And a little bit, so bringing it home to Carson City. So the center, the facility that's in question here, was recently Capital Christian Child Development Center, one of 2 locations that recently closed. So now that they closed, there's only 13 centers with more than 20 children licensed in Carson City. There are more that are more like in-home daycares, but we're more of the bigger daycares. So essentially, I'm looking at some information online with what these 13 centers are licensed for. Basically, we have room for 684 children in Carson City. And only 3 of the centers are QRIS star rate participant, and we are one of them. Pulling some statistics from the Carson City Community Health Needs Assessment, which is in draft form, but I approximate there's about 3,686 children aged 0 through 5 in Carson City. And also that 58, based on National Center for Education Center, 58% of children nationally usually need child care. So that would imply that about a little over 2,000 children in Carson City need it. basically what it's just saying is that we have a big shortfall in child care centers in Carson City. So the facility here, it was built, I think Hope mentioned that earlier, was built specifically for child care. And one thing I might add is it's really hard to find facilities. We've been looking for quite some time to expand, but to renovate a regular commercial building is pretty difficult. There's a lot of specific requirements that you need to meet for child care licensing. Next slide. So we've already, our lease is already signed. We are, of course, pending approval from this planning commission and also child care licensing, which is also in progress. We started renovating. I'll just put in a few numbers there that we already have a lot of families over 50 that are interested in enrolling. 10 have already confirmed without even walking through. And 2 open houses scheduled for this week. So yeah, that's basically it. In summary, I don't think Carson City can afford to lose more child care facilities. We've done a lot of groundwork to get this going, and just asking for your approval. So thank you.
Thank you for that. Are there any questions for the applicant?
One thing I noticed when I drove by, and I appreciate compared to some of the others, is they have to come into the area to drop the kids off. That, the way it's set, you can't hardly even see it from the road, but it's kind of down in that mall area, and it's a nice feature that the kids aren't getting in and out on the street or whatever.
Right, yeah, it's kind of tough.
And thank you for the presentation.
Of course.
Okay. When did the previous child care center close?
They closed May 31st, end of the past month.
Okay. And so they have been no service, no child care services at the facility since the 1st of June?
Yeah, that's correct.
Okay. Just wanted to get that clarified, not that it's that important. Ms. Stowell.
Just a question on the access easement. Would there need to be signage there? I mean, I don't remember seeing signage off of College Parkway just when you come in off of Hot Springs, but if they wanted to have signage on College Parkway, would they be allowed to do that?
No, that would be an off-premise sign.
Okay. Thank you for your presentation. Is there anyone from the public who wishes to address this item? Okay. Bring it back to the commission. Mr. Sattler.
I'll make the motion if you like. Or would you like?
Do you mind?
You made a bunch
tonight. Okay. Thank you. Okay, Elise Monroy for the record. I move to approve SUP 17068, a special use permit to allow a child care facility on property zone limited industrial and located at 1987 Old Hot Springs Road, APN 002-653-10, based on the findings contained in the staff report and subject to conditions of approval.
Second.
We have a motion and a second by Ms. Stowell. Is there any further discussion? All those in favor of the motion signify by saying aye. Aye. Opposed? Motion is approved unanimously. Thank you. And good luck. All right, that concludes the public hearing portion of our meeting. Any item that anybody can appeal the decision of the Planning Commission within 10 days of the Planning Commission's actions. Nobody here to hear that, so. Okay, moving on to item H, staff reports. Mr. Plemmel.
Sure, just a few things that just give you an update on items that were previously before the Planning Commission that went to the Board of Supervisors in June was the multifamily open space zoning amendment, amending the open space requirements a little bit, that small amendment. And also the the big one that we probably can't talk too much about because it's coming back, the Builders Association of Nevada, that the zoning map amendment that you made the recommendation on for their office on Randall Drive. There was also, you had a special use permit that was denied for the childcare. So the Board of Supervisors, they had the hearing and considered things, and they gave direction to us to come back and recraft a planned unit development, anyway, to figure out a process to limit the uses. Understanding we need to get rid of the resolution of intent that limited it, but there's still a concern with uses. So you will see something on your July agenda. I don't want to talk about it too much. You're going to be considering it, but it's going to come back to you for your consideration with limited uses. Also talking about future agenda items, marijuana already came up tonight otherwise, so I anticipate, depending on what the board direction we get next week, I do anticipate an ordinance one way or another coming to the Planning Commission for recommendations on to implement that direction. Kind of on a parallel track to that, you'll probably be considering at the same time a resolution to implement a new moratorium, and that's just that's the contingency plan because it will expire before the ordinance. If anything happens, the ordinance doesn't stay right on track, the moratorium will otherwise expire. So anyway, I think that's how we're going to do it after looking at everything. But we also have a special use permit for a sign at Wendy's on South Carson Street. Another child care special use permit, actually for a new child care facility in the shopping center that's kind of on the corner of Hot Springs Road behind where Denny's is. Pioneer School's doing a school expansion, so there's a special use permit for that. There's also a partial street abandonment related to that, next to that property. And then there's an abandonment of a portion of right-of-way on Hells Bells Road. That's just a cleanup item, really, on right-of-way. It's not an abandonment of the street. And then the last thing I want to note is I've sent an email out to everybody, but next Wednesday, July 5th, is the webinar, the American Planning Association Annual Planning Law Review. So I would encourage you, if you can attend, it's 1 to 2:30. It's always a good one that has an update on the latest Supreme Court cases in the last year related to planning. And it's always interesting to hear what they have to say and what's been going on. That's all I have.
Ms. Sullivan? No?
I was late running in, so before I came in, just before the meeting, have you been introduced to our new city engineer?
He introduced himself.
Okay, thank you. Good job, Dan. Dan Stuckey for the public, replacing Danny, who's moved on. We have a new Dan Stuckey. I could go with Dan here.
We're the Dan Commission here.
Yeah. Thanks for coming.
So we're going to call you Dan. We're going to call you Dan, I guess. And this is Mr. Salerno.
You can call me Dan.
Okay, and I just to point out, just in case the public viewing on TV, we have a new commissioner, Candace Stowall, and welcome, and we look forward to having you on board.
Everybody introduced themselves to her at the beginning. Yes. Before I got here too. Yeah, I'm sorry. Came right on the deadline today. Sorry. Yeah, Candace has. Did you get a chance to tell yourself a little bit about? She has a little bit of experience in planning. If you haven't known, she's professional. She's a professional planner, so she's a good addition to the Planning Commission. So glad to have her. The Board of Supervisors in June, I should have mentioned that too. Obviously, they appointed Candace, but they left one of the spots open, and it's open now. And I think they're having a new round of interviews next week to look to fill the last position.
And we have our election next month, correct?
Chair elections, the next meeting, yes.
My favorite subject. Will there be a follow-up about SB 477 at some point?
Yeah, that's a good idea. And I haven't even I have a list of the approved legislation from the last session. There are definitely that one and at least one or two others that I know of. They're going to require some code amendments, even if not, maybe just minor stuff, but we're going to have to look at that. So I'll provide that's a good update for the Planning Commission for the next meeting, is to provide an update on that. Probably not fix all those ordinances by next meeting, but I'll give you a list of what was done. Thank you.
So is the webinar, is that next Wednesday?
It is.
July 5th?
July 5th.
Okay, July 5th, from 1 to 2:30. Okay. Any commissioners have anything they'd like to add?
Just we have this, just a comment. When we get the new commissioner and do it again, I just need my cell listed because my home phone is gone and I'm at work once in a great while, so, thanks. Don't do the bill.
Okay. No additional comments. Meeting is adjourned at 6:50.
Let's call for public comment.
Oh, yes, public
one more
comment.
time.
Thank you.
I know we don't have anyone here, but just for clarity.
Okay. At this time, I would entertain public comment. Anyone from the public who wishes to address the Planning Commission may do so. Seeing none, meeting is adjourned.
We have two.